Right, thank you. Hi, everyone. My name is Luke Humphreys, and I'm a legal counsel in the credit legal team at the Commission. Welcome to my session on Section 9CA, which requires lenders to keep records of their affordability and suitability assessments. I'll also briefly touch on Section 41A of the CCCFA, which covers record keeping on fees calculations. I'm going to run through what the sections require lenders to do, and why it is important that they have processes in place that comply with these new requirements. So why were these sections introduced? These sections were introduced as part of the wider CCCFA reform in 2019 and came into effect on 1st December 2021. That covers new contracts entered into from that date, as well as any material changes that have been made to existing loans, such as top-ups. It's a key date to keep in mind. While the requirement for ensuring loans are affordable has been in place since 2015, lenders have not had to keep records or provide their affordability assessment until 1st of December 2021. Section 9CA is a key provision in the law for consumer advocates, especially financial mentors who may want to see how a lender calculated affordability for their client's loan. The aim of Section 9CA was to address non-compliance with affordability and suitability assessments. And MB had noted that unaffordable or unsuitable loans were one of the largest sources of harm to borrowers. It was one of three measures introduced as part of a wider drive to clarify affordability and suitability requirements, streamline enforcement, and create stronger incentives for compliance. For reference, these three measures were regulations that prescribe minimum requirements for affordability and suitability tests, an increased onus on lenders to verify details of those who are applying for loans. And this aspect addressed the problems that came from lenders solely relying on what borrowers had told them about their income and expenses. And thirdly, lenders being required to keep records that demonstrate their loans are affordable and suitable, and that their fees are reasonable and cost-based. The sections also improve enforceability of rules around responsible lending by allowing for clear minimum standards to be set and strengthening the penalties for any breaches. For record keeping when it comes to fees, Section 41A recognizes that it is not enough to simply set and forget when it comes to fees. Instead, it is now clear that lenders need to review fees when these costs change. For example, a lender may introduce a more streamlined process for establishing loans, and if that reduces their cost, then their establishment fees should also be reduced as well. Likewise, if compliance obligations increase their costs, then the related fees are also likely to increase. As mentioned earlier, there was previously no legal requirement for lenders to keep these records, which made it difficult to obtain evidence. The sections enable the Commission to obtain records more quickly and focus its investigation on whether the recorded inquiries made were reasonable and were enough for a lender to be satisfied that the loan was suitable and affordable, or that the fees were reasonable, rather than trying to ascertain what inquiries and/or assessments were made. So the question is, what do the record keeping requirements around affordability and suitability actually require of lenders? So Section 9CA requires lenders to make and keep records for at least 7 years that show that they have made the required inquiries about the loan's affordability and suitability for the borrower under Section 9C, including the results of those inquiries. The record must also show how the lender satisfied themselves that the loan met the borrower's requirements and objectives and can be repaid without the borrower suffering substantial hardship, that a guarantor can comply with a guarantee without suffering substantial hardship, and that insurance provided for under an insurance contract meets the borrower's requirements and objectives, and payments can be made without the borrower, again, suffering substantial hardship. So these records may be requested by the Commission, noting that the Commission does not have to use its statutory notice powers to make a request. They can also be requested by a dispute resolution scheme for records that relate to an agreement or relevant insurance contract that is the subject of a dispute under that scheme. A borrower or a representative acting for them, which includes you if you are a financial mentor and have a privacy waiver, may request records about inquiries made by the lender that relate to an agreement or relevant insurance contract to which the borrower is a party. And finally, a guarantor may request records about inquiries made by the lender about how they worked out how the guarantor could afford to guarantee the loan. In terms of the time frame that lenders are required to provide the records for after a request is made, the records must be provided within 20 working days of a request being made, or a longer period if the request is by the Commission and specified by the Commission. And finally, a key thing to note is that a record must be provided free of charge. So, what can you expect to see when you receive a lender's records of their affordability or suitability assessment? So the regulations do not expressly prescribe a format for how the lender must provide those records, but the Responsible Lending Code does provide some guidance about what those records should contain. Section 5.40 provides examples of what a lender should show in their records, such as the likely income and relevant expenses of a borrower over a weekly, fortnightly, or monthly basis. This might be presented looking like a regular budget, but lenders may choose to show this information in other ways. It should show where those expenses were derived from, for example, 90 days worth of bank statements, how income and expenses were verified. For the benchmarkable expenses, if a benchmark has been used for comparison, a brief description of that benchmark could show how adjustments were made if expenses needed to be adjusted to meet a minimum standard of living compared to somebody in similar circumstances, and also what buffers were applied for the budget surplus under which the new loan was made. In our series of lender seminars earlier in the year, we made some general comments about compliance with both record-keeping provisions. We noted that the requirements must be built into a lender's existing CCCFA compliance processes. We noted it was important that the information was recorded and provided shows how the borrower could afford the loan without suffering the substantial hardship. We noted that the Commission or anyone else allowed to request those records should not have to try and work out what was done or struggle to make sense of the records. It should be clearly set out and anyone should be able to see how the lending decision was reached. We noted it was also important that lenders think about their recording obligations at the time of the loan application, rather than creating or pulling together records after a request is received. If the lender receives a request and does not have the required records, and it's likely they have not complied with the requirement and there could be consequences for that. Specifically, in relation to Section 9CA, we noted that providing copies of a borrower's documents and information on its own is unlikely to demonstrate how all necessary inquiries were made. The assessment and calculations will also be required to show how the lender satisfied themselves that the loan was affordable. For example, if bank statements were used to verify information from a borrower, those bank statements must also be provided and records to show how the bank statements were used. Records provided under Section 9CA must show the way the lender stepped through the affordability assessment. For example, we covered off with lenders what we expected the records to contain, which were those items I mentioned earlier, such as the borrower's income and expenses. We noted that it was important that the records show how the lender arrived at their lending decision. It's not just about showing the inquiries the lender made, but also how they used the information gathered to comply with the affordability assessment regulations. The law at Section 4AG of the regulations allows for an exception to the full affordability assessment where it is obvious that a borrower can afford the repayments without hardship. The example in the code set a relatively high bar for this obvious standard. If a lender did rely on this exception, their record should show clearly why. A borrower on a benefit or earning a low income is highly unlikely to qualify for this exception. On occasion, lenders may raise the issue of privacy. Confidential information must be provided to the Commission if it's formed part of the lender's assessment. They could mark it as confidential and explain that when they provide it. The same applies for personal information that's collected from a borrower to meet the requirements of Section 9CA. You may also know that there is a section in the Privacy Act 2020, which confirms that requirements to disclose personal information under the CCCFA sections override any limitations on disclosure under the Information Privacy Principle 11 of the Privacy Act. But if there are any concerns, then in the first instance, you should contact the Commission. I'll also just briefly cover record keeping in relation to fees. Section 41A of the CCCFA requires that lenders keep record about how they calculated credit and default fees under Section 41. The records must demonstrate that the fees were reasonable at the time they were calculated or when they were reviewed. As you may know, the CCCFA requires that the credit and default fees are reasonable, and that means that they only recover the lender's reasonable costs. In other words, lenders cannot make profit from fees. It's important to keep in mind that only the Commission and a dispute resolution scheme can request these type of records. The provision will improve the way that the Commission can check if lenders' fees are reasonable. Previously, if the Commission investigated a fees case, we had to work out what the lender's costs were and see if those fees exceeded that. And as you can imagine, it was often a long, complicated, and costly investigation. Now, lenders must show exactly how their fees were calculated. The Commission provides lenders with comprehensive guidance about how to set those fees and what types of costs they are allowed to recover and what costs they cannot, such as the costs associated with advertising. The fee charged to a borrower must relate to the activity associated with that particular borrower and not cover the costs related to other borrowers' loans. At the recent lenders seminars, we talked about the records that lenders are now required to keep that must be specifically provided to the Commission and dispute resolution schemes when requested. Importantly, we noted that keeping records should be kept at the time the fee is set, as well as when they're reviewed, especially when changes occurred in the business model that could affect their fees. The records must actually demonstrate that each fee was reasonable at the time it was set or reviewed, and the records should include the costs of the lender related to the fees charged and show the connection between the cost and the fee. So the question becomes, what happens if the lenders do not comply with these provisions? If the lenders don't comply with the requirements of the record-keeping provisions, being sections 9CA and section 41A, the Commission has a range of enforcement options available. For example, if the lender breached their obligation under either section, then the Commission could take proceedings, and a court could order the lender to pay pecuniary penalties of up to $600,000 for a company or $200,000 for an individual. If the lender does not comply with the request from a borrower and/or guarantor, their advocate acting on the borrower's behalf, then they may notify the Commission of the non-compliance, in which case the Commission can take enforcement action. The types of enforcement action the Commission can take would be in line with our enforcement response guidelines, which are available on our website. We apply the criteria such as the extent of the harm, the seriousness of the conduct, and the public interest in the matter. There are a range of things that we can do. For instance, we may engage with the lender to provide guidance or write to them, usually for first-time offences, effectively putting them on notice. Or we may investigate, for which the outcome could range between specific compliance advice, a warning letter, settlements, enforceable undertakings, or even court proceedings. So to wrap up, if you have requested an affordability assessment from a lender, just remember that they only have to provide them on contracts or material changes, such as credit limit increases that occurred from 1st December 2021. They will have 20 working days from the date of the request to provide the information, and that they should not be charging any fees for that request. It's a good idea to make that request by email and work out the last day that the information must be provided on and add that to your request for clarity. It may also be a good idea to put a read receipt on your email so that you know it's been received and opened. If you don't get a response within the 20 working day timeframe, please notify us at the Commission, and the easiest way to do that is to simply email us at notify@comcom.govt Thank you. I hope that's been useful.